Now let's talk about venue. First, let us distinguish between jurisdiction and venue. Jurisdiction over the subject matter or nature of an action is conferred only by law. It may not be conferred by consent or waiver upon a court which otherwise would have no jurisdiction over the subject matter of an action. On the other hand, the venue of an action as fixed by statute may be changed by the consent of the parties, and an objection on improper venue may be waived by the failure of the defendant to raise it at the proper time. In such an event, the court may still render a valid judgment. Rules as to jurisdiction can never be left to the consent or agreement of the parties. Venue is procedural, not jurisdictional, and hence may be waived. It is meant to provide convenience to the parties rather than restrict their access to the courts as it relates to the place of trial. Rule 9, Section 1 of the 1997 Rules of Civil Procedure states that defenses and objections not pleaded either in a motion to dismiss or in the answer are deemed waived. The court may only dismiss an action motu proprio in case of lack of jurisdiction over the subject matter, litis pendentia, res judicata, and prescription, and not when the ground is improper venue. What is the venue of real actions? Actions affecting title to or possession of real property or interest therein shall be commenced and tried in the proper court which has jurisdiction over the area wherein the real property involved or a portion thereof is situated. So what is the proper court? It depends on the assessed value. Remember, both the RTCs and MTCs have jurisdiction over real actions, but depending on the assessed value. Forcible entry and detainer actions shall be commenced and tried in municipal trial court of the municipality or city wherein the real property involved or a portion thereof is situated. The venue is local, meaning the venue is the place where the real property involved or any portion thereof is situated. How about personal actions? Personal actions may be commenced and tried where the plaintiff or any of the principal plaintiffs resides, or where the defendant or any of the principal defendants resides, or in the case of a non-resident defendant, where he may be found at the election of the plaintiff. Where is the venue against non-residents? So for personal actions and the defendant is a non-resident but temporarily found in the Philippines, the venue shall be where he may be found at the plaintiff's election. But if it is a real action, then of course the rule is where the property or a portion thereof is situated. How about venue against non-residents not found in the Philippines? If any of the defendants does not reside and is not found in the Philippines, and the action affects the personal status of the plaintiff or any property of said defendant located in the Philippines, the action may be commenced and tried in the court of the place where the plaintiff resides, or where the property or any portion thereof is situated or found. If the action affects the status of the plaintiff, it is an action in rem. Likewise, if the defendant has property in the Philippines, the action directed involving said property could fall as a quasi-in rem action. For in rem and quasi-in rem actions, jurisdiction over the defendant is not necessary, if you remember our discussion on that topic, as long as jurisdiction over the rest is acquired. However, summons must still be served to satisfy the requirement of due process. What are the instances when the rules on venue do not apply? The rules on venue shall not apply, first, in those cases where a specific rule or law provides otherwise, or second, where the parties have validly agreed in writing before the filing of the action on the exclusive venue thereof. Okay, an example of the first instance when the rules or substantive law provides otherwise is an action for damages arising from libel. The revised penal code provides for specific venue rules that are not the same as the general rule. Another instance is when the Supreme Court orders the change of venue to avoid miscarriage of justice. This power is provided for under the Constitution as a power of the Supreme Court. The next instance when the general rules on venue do not apply is when the parties have validly agreed in writing before the filing of the action on the exclusive venue thereof. Okay, the general rule is that the venue of real action is the court which has jurisdiction over the area wherein the real property involved or any portion thereof is situated, while the venue of personal actions is the court which has jurisdiction where the plaintiff or the defendant resides at the election of the plaintiff. As an exception, jurisprudence instructs that the parties, through a written instrument, may either introduce another venue where actions arising from such instrument may be filed, or restrict the filing of said actions in a certain exclusive venue. In Legazpi v. Republic of the Philippines, the court held that the parties are not precluded from agreeing in writing on an exclusive venue as qualified by Section 4 of the Rules of Court. Written stipulations as to venue may be restrictive in the sense that the suit may be filed only in the place agreed upon, or merely permissive in that the parties may file their suit not only in the place agreed upon, but also in the places fixed by law. As in any other agreement, what is essential is the ascertainment of the intention of the parties respecting the matter. As regards restrictive stipulations and venue, jurisprudence instructs that it must be shown that such stipulation is exclusive. In the absence of qualifying or restrictive words, such as exclusively, waiving for this purpose any other venue, shall only, preceding the designation of venue, to the exclusion of the other courts, or words of similar import, the stipulation should be deemed as merely an agreement on an additional forum, not as limiting venue to the specified place. So what are the elements or the requirements for an exclusive or restrictive stipulation and venue to be valid? The mere stipulation and the venue of an action, however, is not enough to preclude parties from bringing a case in other venue. In the absence of restrictive words, the stipulation should be deemed as merely an agreement on an additional forum, not as limiting venue. Okay, so while they are considered valid and enforceable, venue stipulations in a contract do not, as a rule, supersede the general rule set forth in Rule 4 in the absence of qualifying or restrictive words. If the language is restrictive, the suit may be filed only in the place agreed upon by the parties. An exclusive venue stipulation is valid and binding provided that it is expressed in writing by the parties thereto, it is entered into before the filing of the suit, and the stipulation on the chosen venue is exclusive in nature or in intent. Here is an example of an exclusive venue stipulation in a contract. So the stipulation provides, should any of the party renege or violate any terms and conditions of this lease contract, it shall be liable for damages. All actions or cases filed in connection with this lease shall be filed with the Regional Trial Court of Pasay City, exclusive of all others. Okay? The provision clearly shows the party's intention to limit the place where actions or cases arising from a violation of the terms and conditions of the contract of lease may be instituted. This is evident from the use of the phrase exclusive of all others and the specification of the locality of Pasay City as the place where such cases may be filed. Question: what if the plaintiff assails the validity of the instrument stipulating an exclusive venue? Briones v. Court of Appeals, GR number 4444. This is a 2015 decision. The Supreme Court held that in cases where the complaint assails the terms, conditions, and/or coverage of a written instrument and not its validity, the exclusive venue stipulation contained therein shall still be binding on the parties, and thus the complaint may be properly dismissed on the ground of improper venue. Conversely, therefore, a complaint directly assailing the validity of the written instrument itself should not be bound by the exclusive venue stipulation contained therein, and should be filed in accordance with the general rules on venue. To be sure, it would be inherently inconsistent for a complaint of this nature to recognize the exclusive venue stipulation when it, in fact, precisely assails the validity of the instrument in which such stipulation is contained. In this case, the venue stipulation found in the subject contracts is indeed restrictive in nature, considering that it effectively limits the venue of the actions arising therefrom to the courts of Makati City. However, it must be emphasized that Briones' complaint directly assails the validity of the subject contracts, claiming forgery in their execution. Given this circumstance, Briones cannot be expected to comply with the aforesaid venue stipulation, as his compliance therewith would mean an implicit recognition of their validity. Hence, pursuant to the general rules on venue, Briones properly filed his complaint before a court in the city of Manila where the subject property is located. Now, what if the plaintiff does not reside in the Philippines? Ang versus Spouses Ang, GR number 186993, August 22, 2012. The facts in this case. Respondents obtained a loan from petitioners. However, despite repeated demands, the respondents failed to pay the petitioners. Notwithstanding the receipt of a demand letter, the respondents still failed to settle their loan obligations. The petitioners, who were then residing in Los Angeles, California, United States of America, executed their respective special powers of attorney in favor of Attorney Eldridge Marvin Aceron for the purpose of filing an action in court against the respondents. Attorney Aceron, on behalf of the petitioners, filed a complaint for collection of sum of money with the RTC of Quezon City against the respondents. Respondents moved for the dismissal of the complaint filed by the petitioners on the grounds of improper venue and prescription. Insisting that the venue of the petitioners' action was improperly laid, the respondents asserted that the complaint against them may only be filed in the court of the place where either they or the petitioners reside. They averred that they reside in Bacolod City, while the petitioners reside in Los Angeles, California, USA. Thus, the respondents maintain the filing of the complaint against them in the RTC of Quezon City was improper. The respondents further claimed that the petitioner's grant of special power of attorney in favor of Attorney Aceron, notwithstanding, the said complaint may not be filed in the court of the place where Attorney Aceron resides, that is, RTC of Quezon City. They explained that Attorney Aceron, being merely a representative of the petitioners, is not the real party in interest. Accordingly, his residence should not be considered in determining the proper venue of the complaint. The issue in this case is whether or not venue was properly laid. Contrary to the Court of Appeals disposition, the petitioners maintain that their complaint for collection of sum of money against the respondents may be filed in the RTC of Quezon City. Invoking Section 3, Rule 3 of the Rules of Court, they insist that Attorney Aceron, being their attorney in fact, is deemed a real party in interest in the case and can prosecute the same before the RTC. Such being the case, the petitioners assert that a said complaint for collection of sum of money may be filed in the court of the place where Attorney Aceron reside. or resides, which is the RTC of Quezon City. Do you agree? The Supreme Court held that the petitioner's complaint should have been filed in the RTC of Bacolod City, the court of the place where the respondents reside, and not in RTC of Quezon City. The petitioner's complaint for collection of sum of money against the respondents is a personal action as it primarily seeks the enforcement of a contract. The rules give the plaintiff the option of choosing where to file his complaint. He can file it in the place where he himself or any of them resides, or where the defendant or any of the defendants resides or may be found. The plaintiff or the defendant must be residents of the place where the action has been instituted at the time the action is commenced. However, if the plaintiff does not reside in the Philippines, the complaint in such case may only be filed in the court of the place where the defendant resides. In the case of Cohen and Cohen versus Benguet Commercial, the Supreme Court held that there can be no election as to the venue of the filing of a complaint when the plaintiff has no residence in the Philippines. In such case, the complaint may only be filed in the court of the place where the defendant resides. Here, the petitioners are residents of Los Angeles, California, USA, while the respondents reside in Bacolod City. Applying the principles, the petitioner's complaint against the respondents may only be filed in the RTC of Bacolod City, the court where the place or the court of the place where the respondents reside. The petitioners, being residents of Los Angeles, California, USA, are not given the choice as to the venue of the filing of their complaint. Please take note that the residence of the attorney-in-fact is not the basis of venue. In this regard, it bears stressing that the situs for bringing real and personal civil actions is fixed by the rules of court to attain the greatest convenience possible to the litigants and their witnesses by affording them maximum accessibility to the courts. And even as the regulation of venue is primarily for the convenience of the plaintiff, as attested by the fact that the choice of venue is given to him, it should not be construed to unduly deprive a resident defendant of the rights conferred upon him by the rules of court. Indeed, to construe the express requirement of residence under the rules on venue as applicable to the attorney-in-fact of the plaintiff would abrogate the meaning of a real party in interest. There is nothing in the rules that expressly allows, much less implies, that an action may be filed in the city or municipality where either a representative or an attorney-in-fact of a real party in interest resides. Section 3 of Rule 3 merely provides that the name or names of the person or persons being represented must be included in the title of the case, and as such person or persons shall be considered the real party in interest. In other words, the principal remains the true party to the case and not the representative. Under the plain meaning rule or verba legis, if a statute is clear, plain and free from ambiguity, it must be given its literal meaning and applied without interpretation. It bears stressing that the rules on venue, like the other procedural rules, are designed to ensure a just and orderly administration of justice or the impartial and even-handed determination of every action and proceeding. Obviously, this objective will not be attained if the plaintiff is given unrestricted freedom to choose the court where he may file his complaint or petition. The choice of venue should not be left to the plaintiff's whim or caprice. He may be impelled by some ulterior motivation in choosing to file a case in a particular court, even if not allowed by the rules on venue. Marcos Araneta versus Court of Appeals. In this case, Marcos Araneta filed a complaint for conveyance of shares of stock, accounting, and receivership against Benedicto Group before the RTC in Batac, Ilocos Norte. A motion to dismiss was filed on the ground of improper venue. The RTC dismissed the complaints on the ground of improper venue. Pending resolution of her motion for reconsideration, Marcos Araneta filed an amended complaint in which the names Daniel Rubio, Orlando Reslin, and Jose Reslin appeared as additional plaintiffs. As stated in the amended complaint, the added plaintiffs, all from Ilocos Norte, were her new trustees. The RTC issued an order granting the amended complaint. So the issue in this case is whether or not venue was properly laid. First, the Supreme Court distinguished between a personal and real action. It answered the question of whether or not the case is a personal or real action, because if it was a real action, the venue would be where the property is located. If it is a personal action, then there is a question of the residence of the parties. The Supreme Court held that in a personal action, the plaintiff seeks the recovery of personal property, the enforcement of a contract, or the recovery of damages. Real actions, on the other hand, are those affecting title to or possession of real property or interest therein. In accordance with the wordings of Section 1 of Rule 4, the venue of real actions shall be the proper court which has territorial jurisdiction over the area wherein the real property involved or a portion thereof is situated. The venue of personal actions is the court where the plaintiff or any of the principal plaintiffs resides, or where the defendant or any of the principal defendants resides, or in the case of a non-resident defendant, where he may be found at the election of the plaintiff. In the instant case, petitioners are basically asking Benedicto and his group as defendants to acknowledge holding in trust Marcos Araneta's purported 65% stock ownership. In other words, Marcos Araneta seeks to compel recognition of the trust arrangement she has with the Benedicto Group. The fact that the assets include real properties does not materially change the nature of the action, for the ownership interest of a stockholder over corporate assets is only inchoate as the corporation, as a juridical person, solely owns such assets. It is only upon the liquidation of the corporation that the stockholders, depending on the type and nature of their stock ownership, maybe have a real inchoate right over the corporate assets, but then only to the extent of their stock ownership. Okay? So the action here is a personal action. There can be no serious dispute that the real party in interest, plaintiff, is Marcos Araneta. As self-styled beneficiary of this disputed trust, she stands to be benefited or entitled to the avails of the present suit. It is undisputed, too, that petitioners Daniel Rubio, Orlando Reslin, and Jose Reslin, all from Ilocos Norte, were included as co-plaintiffs in the amended complaint as Marcos Araneta's new designated trustees. As trustees, they can only serve as mere representatives of Marcos Araneta. Irene Marcos Araneta stands undisputedly as the principal plaintiff, the real party in interest. Following Section 2 of Rule 4, the subject civil cases ought to be commenced and prosecuted at the place where Irene resides. So where does Irene resides? No less than the RTC in Batac declared that Irene as not a resident of Batac, Ilocos Norte. That court was an improper venue for her conveyance action. The court can concede that Irene's three co-plaintiffs are all residents of Batac, Ilocos Norte, but it ought to be stressed in this regard that not one of the three can be considered as principal party plaintiffs, included as they were in the amended complaint only as trustees of the principal plaintiff. As trustees, they may be accorded by virtue of Section 3, Rule 3, the right to prosecute a suit, but only on behalf of the beneficiary, who must be included in the title of the case and shall be deemed to be the real party in interest. In the final analysis, the residences of Irene's co-plaintiffs cannot be made the basis in determining venue of the subject suit. Okay? This conclusion becomes all the more forceful considering that Irene herself initiated and was actively prosecuting her claim against Benedicto, his heirs, assigns, or associates, virtually rendering the impleading of the trustees unnecessary. And this brings the court to the final point, that Irene Marcos Araneta was a resident during the period material of Forbes Park, Makati City. She was not a resident of Barangay Lacub, Batac, Ilocos Norte, although jurisprudence has it that one can have several residences, if such were the established fact. The court will not speculate on the reason why petitioner Irene, for all the convenience and expenses she and her adversaries would have to endure by a Batac trial, preferred that her case be heard and decided by the RTC in Batac. On the heels of the dismissal of the original complaints on the ground of improper venue, 3 new personalities were added to the complaint, doubtless to ensure, but in vain, as it turned out, that the case stays with the RTC in Batac. Improper venue is not a ground for the motu proprio dismissal of a case. Venue may be waived expressly or impliedly. Under Section 4, Rule 4 of the old rules, an agreement to venue may be impliedly made by the defendant when he fails to seasonably object to it. While the present 1997 Rules of Civil Procedure, particularly Section 1, Rule 9 thereof, does not contain provisions similar to Sections 3 and 4 of the old rules, the deletion, however, cannot be taken to mean that objection to venue may still be made in an answer if no motion to dismiss is filed. So under the new rules, a court may motu proprio dismiss a claim when it appears from the pleadings or evidence on record that it has no jurisdiction over the subject matter, when there is another cause of action pending between the same parties for the same cause, or where the action is barred by a prior judgment or by statute of limitations. Improper venue not being included in the enumeration, it should follow that motu proprio dismissal on said ground would still not be allowed under the 1997 Rules of Civil Procedure. Dismissing the complaint on the ground of improper venue is certainly not the appropriate course of action, particularly as venue in inferior courts as well as in the courts of first instance before and now the RTC may be waived expressly or impliedly. Where the defendant fails to challenge timely the venue in a motion to dismiss, as provided by Section 4 of Rule 4 of the Rules of Court, and allows the trial to be held and a decision to be rendered, he cannot on appeal or in a special action be permitted to belatedly challenge the wrong venue, which is deemed waived. Thus, unless and until the defendant objects to the venue in a motion to dismiss, the venue cannot be truly said to have been improperly laid. As for all practical intents and purposes, the venue, though technically wrong, may be acceptable to the parties for whose convenience the rules on venue had been devised. The trial court cannot preempt the defendant's prerogative to object to the improper laying of the venue by motu proprio dismissing the case. In one case, the court ruled that it was grossly erroneous for the trial court to have taken a procedural shortcut by dismissing motu proprio the complaint on the ground of improper venue without first allowing the procedure outlined in the rules of court to take its proper course. Although we are for the speedy and expeditious resolution of cases, justice and fairness take primary importance. The ends of justice require that respondent trial court faithfully adhere to the rules of procedure to afford not only the defendant but the plaintiff as well the right to be heard on his cause. In one case, the court held that Section 6, Rule 16 of the 1997 Rules of Civil Procedure further provides that if no motion to dismiss has been filed Any of the grounds for dismissal provided under the rules, including improper venue, may be pleaded as an affirmative defense in the answer, and upon the discretion of the court, a preliminary hearing may be made thereon, as if a motion to dismiss has been filed. But, as it is, improper venue not having been raised by respondent as a ground in a motion to dismiss, he must be deemed to have waived the same.